Yeah, I do. One for you, one for Alonso, one for Charles.
All right, this evening's agenda, two items, Rivera recall number 1, review of hearing schedule of proceedings, and Rivera recall number 2, affidavits, issuance of petition.
Want me to take attendance, Mr. Chairman?
Yes, please, attendance.
Board of Registrars, Aldonza Pereira.
Present.
A little
Did a
better.
better job.
Yeah, you're starting off better tonight.
Thank you. Myself, present. City Attorney Charles Body.
Present but
And-
not as a member tonight.
Chairman Nick Petrakis. All present, not as a member, Mr. Body?
Correct, because it's not a hearing on objections.
Right. Mr. Chair.
All right, for Rivera recall number 1, review of hearing schedule of proceedings, are we able to proceed on Saturday? Someone come to the microphone, please.
Yes, we are.
So Saturday at 10 o'clock?
Yes.
Good to go. Do you have all of your subpoenaed witnesses, and they're prepared to appear?
Depending on what happens tonight, it's most likely we'll not be subpoenaing witnesses, although we have the subpoenas, and we'll make a determination later this evening.
Very good.
I anticipate there's 31 paragraphs left. I'm thinking 2 hours, and then whatever the other side has, so a guesstimate.
Thank you.
Okay.
I'll just leave it at that. I have no question.
Yeah, I have some questions, but you know,
Well, I have a persistent gnaw in my head about a subpoena, but I'm not going to ask it today.
all right.
Yeah, I'm going to leave it. I'm
So-
satisfied.
So, on to article number 2, Rivera recall 2 affidavits, issuance of petition. We have the report?
My report is simple, and I did not bring in Mr. Reyes, and I'll explain a couple of the reasons, and I may have inquiry for the city attorney in his capacity as city attorney on a couple of matters, but I'll only say this at this point. On, what was that, the 23rd? I'm trying to remember the date, excuse me.
It was last Friday,
I'm looking at the
would have
date.
been the 23rd, yeah.
23rd, yes. The days are beginning to gel. On the 23rd, we received 336 affidavits from a petitioner represented by Ms. Jennifer Lopez. And forgive me, I forget the name of the,
Citizens for Justice in Lawrence.
thank you, Citizens for Justice in Lawrence. And all the petitions were stamped in the same manner as any prior petition or any petition, not petitions, affidavits, excuse me. Side A, side B, signatures appearing mostly on side A. In any event, they were recorded. The city attorney was present when they arrived. I requested the city attorney to review the affidavits to determine whether or not it had the legal sufficiency as an affidavit. The report verbally at that time was that it did. And based upon what was submitted, the city clerk is prepared pursuant to the charter to issue the petitions to the affidavits for signatures. The city clerk had not caused and does not see any compulsion or requirement to perform any review of any of the signatures presented on affidavit by either the city charter or by any other statute, law, or case law. And based upon that advice and counsel, the petitions, I'm making a motion at this point that the board authorize the city clerk to issue the petitions. Not yet. Is there a second
I
on that
second the
motion?
motion.
If I could record it, please. Mr. Chair, I'll open the floor to your guidance as to whether or not anybody wants to be heard on the matter.
You want to speak, Mr. Singh?
Thank you, Mr. Chair. I believe that this proceeding is being handled a little bit differently than the first affidavit that was submitted, and I think that the city clerk explained why he doesn't believe he's under any compulsion to follow any other procedure than he has today. That's fine with respect to the issuance of those petitions. However, we will be objecting, as we believe we have a right to do.
Of course.
And where it's more of a question to this body, is anything else, is this body intending to follow the procedure that has already been laid out by Judge Ames in the previous affidavit? And the reason we ask is because if it is this board's petition, suggestion, or position, I should say, that the petitions are going to issue and that we will not have an opportunity to object, then we'll be right back in front of Judge Ames tomorrow asking for her to essentially, if not rubber stamp, but direct this board again, because it's exactly the same procedural mechanism as she did last time. And so that's the only thing I'm trying to clarify, because I know what the board's position has been, and that's been legally framed in front of Judge Ames. There is no appeal pending. There is no stay of that order pending. And quite frankly, procedurally, this is no different. And I think that Judge Ames was very clear in her ruling, and I think she was also very upset, as she explained to counsel on the day of the hearing, that this body issued those petitions knowing that we were going to be before her and before her making a ruling. So I ask for clarification, if you will, on that, just to get a sense of where the board is with that.
If I may respond, Mr. Chair.
Please.
I would like a moment.
Before you answer, I want to address one point made by Mr. Tabit. Absolutely not did this clerk issue the petitions knowing that there were petitions about to be issued or the reason therefore. In fact, the evening before the petitions were prepared and ready to go, before you even entered a foot into the court. And I want to make that very clear, that there was not anything intentional or anything intended to beat you to the courthouse. In fact, I was advised by the city attorney that night, who will confirm that I was here about 5:30, I think, is the hour, and the petitions were about to issue, and they suggested I close the doors. So there was nothing that was done, and I took those petitions back and actually waited till the next day. So I resent any implication whatsoever that there was anything done intentionally by the city clerk to kind of beat you to the courthouse door. And that's what you're saying. I'll stop at that.
I have a brief statement to make. I'm very confused. I didn't know that I needed to lawyer up, because this gentleman here who came to discuss issues regarding recall 1, for whatever better term I don't know what to use, but under no circumstance, and the little that I know about law, tells me that each recall 1 and recall 2 are two separate activities that are happening in the city. Why is this attorney referring to orders that were issued or imposed on recall number 1 on my recall? Confuses me. And if he is right, which I do not know, but I feel that he is not, he has no business in mentioning any order that a court had issued for recall 1. Number 1, I have nothing to do with recall 1. I didn't even sign it. This is a new matter, so do not confuse me by making any reference to recall 1. Because if that is the case, and whatever he said, you're holding and gonna give it some value, then I want all of this to stop until I get an attorney here in place that will defend me, because he's a shark, and I'm all confused with the whole issue about why are you talking about recall 1 on my issue? When I didn't even sign the recall 1, I'm not involved.
Direct your comments to the board.
Oh, okay, I'm sorry. But since he Shucko, I thought, let me join in. But nevertheless, I don't want to make this long and lengthy.
I have one more
But I'm
question.
very
Ma'am,
confused.
I have one more request of you, all right?
Yes.
That you not use unnecessary adjectives like shark.
Okay, you're right.
He's not a shark.
You're
Clearly,
right.
He's a person.
You're right, I'm sorry. Obviously, it was a compliment due to the fact that he had a nice chuckle. But nevertheless.
I'm sure he takes it as,
Exactly. No, and you know what? I don't want to come up here, but I'm in all honesty, I'm confused as to why he's even talking about recall one.
your statement's noted. The best I could say is that he's the counsel for the mayor, and that they believe that there's precedent.
It doesn't matter. I object to whatever he said, making reference to recall one on my matter. I think it's actually illegal,
All right, thank you for your
because
comments.
that's a pending case.
Thank you for your comments.
Thank you.
Mr. Chair, if I may interject at this point, thank you, Ms. Lopez. I would, at this point, suggest that the board defer to the city attorney in its proceedings as to recall two. Having heard from both sides of this, I believe it might be helpful. City attorney body,
Well,
You have the floor.
we do have a court order on the first recall that orders us to entertain objections. There haven't been any objections filed on this recall, so I think until objections are filed, discussion on whether the filing of objections would stay anything is premature. I mean, I'm assuming that, that objections will be filed, but none have been filed, so I really don't choose to embark on giving legal opinions on hypotheticals that haven't occurred.
if I may, Mr. Chair, through you, I have a couple of questions for the city attorney, and for the record, it's attorney body. In regard to the affidavits that are filed on recall two, do you find they are legally sufficient as affidavits?
It's my opinion, having reviewed them very closely, that they are. I would have advised you not to accept them if upon initial review they didn't appear to meet the standards of an affidavit.
And again, for the record, as opposed to anything else, we've had this conversation when they were being accepted, and I believe I would not have accepted them, certainly if that advice was
We have a history, just for the benefit of the board, we have had historically, we had a recall that issued when the documents that began it were not affidavits. And I was very upset that we had begun a process without affidavits. And the result of that initial error is that every recall that has happened since, and there have been at least 3, if not 4 or 5 since then, we review specifically to make sure that they are begun as affidavits. There's a case, and all counsel here are very aware that there's a case out of Winchester where a recall was commenced, required to be commenced by an affidavit, was not commenced with an affidavit, and this court threw it out. So on that basis, when somebody presents what purports to be an affidavit for a recall, the city clerk and I look them over. And in this case, seeing that they were sworn under the pains and penalties of perjury, we determined that they met the criteria as affidavits, and we could then act on them.
The other question I would, it's not really a question, I'd like to, Mr. Chair, read into the record the first paragraph, if you will, of the body of the Recall 2 petition, stating, quote, "I, the undersigned registered voter in the city of Lawrence, Mass., hereby on my own free will make and sign this affidavit under the pains and penalties of perjury and upon my personal knowledge and information that I believe to be true, any allegation contained herein." And I'll stop there, end quote. On that basis, I believe, and with the advice of the city attorney as to the legal sufficiency of the affidavit, and again, I'll read into the record under Section 9.7 of the recall of elected officials, Section B, recall petitions. 100 or more voters may file with the city clerk an affidavit containing the name of the officer whose recall is sought and statement on the grounds upon which the petition is based not less than 12 months prior to the expiration of the term of office, period. The names on the affidavit shall be from the city at large. And again, the only comment I will make in regard to both of those sections is that I see nothing before this board that, on my motion, to issue the petitions, for authorization to issue the petitions, that prohibits the board from authorizing and the clerk to issue the petitions on recall number 2 based on the affidavits filed under their oath. And that oath, if it's to be challenged, should be challenged by statute. Mr. Chair.
May I,
I'm
Mr.
finished.
Chair?
Please.
The only thing is this, I know that Attorney Body suggested that we haven't filed any objections yet. The city charter just say voters. That presupposes or presumes registered voters. So my question to this board is, has someone determined that those are registered voters? Because we cannot, I don't believe, object until that determination has been made. It says voters. Obviously, they can't be non-registered voters. It'd be nonsensical. So I know in the past, Mr. Reyes has been here and has done his work through the clerk's office and indicated that in accordance with his report and his review of the names, that they're registered voters. I haven't heard that yet this evening. So I would ask if that's what's being determined, that those 336 are registered voters, or to the extent that they are, that over 100 are, and then we would file our objections, and then I know you don't have to listen to those. You could proceed if you wish and force us to go to court, and I understand that, but we haven't heard that they're registered voters.
Again, if I may, Mr. Chair.
The first sentence.
There are two reasons, and I'm certainly not feeling that any sense that I'm under any obligation even to answer your question. I have a statement from a voter. It says very clearly, I, the undersigned registered voter. I believe him. You may not.
Well, you didn't say that before, Mr. Maloney.
Mr. Tabit, if you're going to yell at me, sit down. The second thing is, this board has made it very clear of its disfavor with the Ames decision and believes that it's wrong by its vote. And you said there was nothing that this board has done that would stop it to answer Judge Ames's decision. I think that's incorrect and misleading. This board has directed the city attorney to file an appeal. He has reported to this board that he's in the process of researching and filing that appeal, that he has filed a motion for reconsideration. I think these are all very significant steps toward filing that appeal. Although I don't have the document in front of me
I take your word for
docketing
it.
the appeal,
How's that?
I do believe that this board has taken affirmative steps to appeal the decision because of its incorrectness. And based upon that incorrectness of the decision, should it be upheld or determined that way until it's determined otherwise, that this board has no opportunity, or no, let me say it another way, no choice but to follow what the charter is saying. If you have an objection about the affiant, what you're suggesting may be criminal and possibly civil contempt.
We have gone over this. We've gone over this repeatedly, and while I understand your position, a Superior Court judge has ruled otherwise. Having said that also...
Not on these.
Mr. Clerk,
Not on these,
Clerk,
Mr.
on the
Tabit.
last affidavit, 35 of them were knocked off.
Yeah.
Okay,
On
so
which
you
one?
obviously
This one?
did a review at
Wait,
that
wait,
time.
Okay. 35
180-something signatures were
We're not-
submitted,
we're not-
affidavits.
yeah.
And 35 of them were not, I don't know, I don't want to say certified, because I know they were considered invalid, if you will. In this instance, there's been nothing that the clerk's office has done, or anyone else, to verify that. Now, your suggestion may now be that you're not required to do so, but that goes against the precedent that has been set over years in this city.
I disagree with you, Mr. Tabid. You said there is nothing that's before this board. I'm going to say it again. I, the undersigned registered voter, apparently you have some skepticism. And I may too, at some point, but show me the evidence when you get these petitions or you get these affidavits. They may in fact be knocked off, as you're saying. But right now, they're affidavits. And they're only affidavits. And if you're thinking that somebody is not telling the truth, you know the course of action. The district attorney will be notified, and if there's fraud being committed, and if you're going to allege that, I don't suggest you are, that it be done distinctly.
This is not about an allegation as to that. This is about the procedure which we believe is required. I don't need to go to the DA's office because I can just go back to Judge Ames, which is what we intend to do. So it's not about alleging anything. It's about a procedure and process that we believe we're entitled to, and you do not, and I understand and respect that. I'm just trying to get some guidance with your vote tonight as to what direction we need to go down. That's all. I understand your position and respect that position. We just need to know what course of action we're going to take.
Excuse me.
Thank you.
Thank you, Mr. Tabib. Anything else? I'm sorry.
I don't have anything.
At this point, I renew my motion to issue the petitions. There's a second on the table. All in favor signify by saying aye. Aye. All against? No. Roll call. Aldonza Pereira. I'm getting better at it. Present or yes?
Not much.
Yes? Present is different. William Maloney, yes. Attorney Barty, you're not a member as to this?
No, I'm not. I
for
only
this purpose?
sit for objections.
And Chairman Petrakis.
Yes.
Motion carries 3-0. I have drafted, by way of information, I have drafted a petition I've submitted to the city attorney for review, who's reviewing it. I'm not quite sure when it'll be ready for and available to circulate. I'd ask that the petitioners stay in touch with my office and I'll stay in touch with you to let you know when they are ready for delivery. That's all I have.
If there's
Anything
nothing
else,
else
Counsel?
before the board, council, no? Then I'll like to hear a motion for adjournment.
You're the first, I'll second on an adjournment at 5:30. Adjourned. This board's adjourned.